Hi, I'm Robert Whitley Jr. with the Whitley Law Firm, and I've had the honor and privilege of representing injured workers in North Carolina for over 12 years. I practiced law with my father, Bob Whitley, who has been representing injured workers since 1974. Together, we have been the voice for thousands of injured workers and their families as they've had to navigate through the workers' compensation system and ultimately receive a fair and just resolution of their claim. And we've learned that when you're seriously injured on the job, you need information because, unfortunately, sometimes the only source of information is the adjuster who works for the insurance company, and that adjuster is under no legal obligation to answer all of your questions and to explain each and every benefit that you're entitled to. In the information that follows, we answer your questions, such as, what benefits am I entitled to when I'm out of work and in need of medical treatment? Who is the adjuster? What are their obligations, and who do they work for? Am I entitled to receive mileage for reasonable medical treatments? What can be done about late checks and when they don't come on time in the mail? And when does it become necessary to hire an attorney to help make sure that your benefits are protected? We've attempted to answer these and other questions because we know that you need information because it may be the difference between receiving a fair and just resolution and being treated unfairly by the insurance company. What triggers a workers' compensation claim? An on-the-job injury by accident triggers a workers' compensation claim. In other words, if you're hurt while on the job or on the clock, you will have a workers' compensation claim. And when you're hurt on the job, fault is irrelevant. In other words, it doesn't matter if it's your fault, a coworker's fault, or your employer's fault. The only question is whether you were hurt on the job. And you must be injured by accident. And an accident is defined as something unusual occurring that causes the injury. The clear example of that is when you fall down at work or somebody runs into you and you have an injury. Any accident or anything unusual that results in injury will start a workers' compensation claim. The second event that triggers a workers' compensation claim is a specific traumatic injury to your back. A back or a spine injury is different from an injury to other parts of your body because with your back, there's no requirement that you have an injury by accident. If you injure your back performing your normal job in the normal way, it is a workers' compensation claim. Let me give you an example that will explain the differences between the two. When I was in high school and college, I had a job stocking groceries. That job required me to have to bend down, pick up boxes, lift them, and then stock them on a shelf. If I were lifting that box and injure my shoulder while picking it up, that would not be a workers' compensation claim because I injured my shoulder performing my regular job in the regular way. However, if I were to fall down while trying to pick up the box and injure my shoulder, that would be covered because I had an injury by accident. Now, remember, with your back it's different. If I were picking up the box in the normal way and injure my back, that would be covered because there's no requirement that I injure my back by accident. The third event that triggers a workers' compensation claim is what's called an occupational illness or disease. And this can best be defined as when an injured worker is exposed over a period of time to a harmful element in their work environment. And this can be exposure to either chemicals or other harmful toxins in the air while working, or it could be repeated use of your hands over time, developing problems in your hand. So the difference between an occupational illness and an on-the-job injury is that there does not have to be a showing of an injury due to a specific event. This is an injury that occurs over time. I'd like to talk first about the responsibilities and duties of the injured worker. And here it is critical that the injured worker do everything that they're supposed to do after the occurrence of an injury in order to protect their benefits. I have seen so many situations where a worker did not understand the rules and not know who they were supposed to report the injury to and end up losing valuable benefits. Once an injury occurs, it is critical that the injured worker report the injury in writing to their supervisor. And this is true no matter how serious or minor you think the injury is, and no matter what happened. In fact, there is a statutory requirement that the injured worker provide written notice. North Carolina General Statute 9722 states, on the occurrence of an accident, every injured employee or his representative must immediately or as soon thereafter as practicable give written notice of the accident to employer. No compensation will be payable unless such written notice is given within 30 days of the accident or death, unless the Commission is satisfied that a reasonable excuse exists for not giving notice. It's real important that the written notice include certain information about the injury. The notice should include the name of the employee, name of employer, the date that the injury happened, and details about how the injury occurred. It's important that all of this information be included because in the event that there's a question later about the date the injury happened or whether the injury was even reported, it's important that that injured worker have a copy of this written notice that includes this information, as it may be the difference between the claim being accepted or denied. The next step that an injured worker must take after an injury is to receive medical treatment if they're injured. The way that a workers' compensation claim is documented, or an injury is documented, is through medical records. And here, if there is an injury, it's going to be important to talk to your supervisor or employer, whoever is the responsible person at work in regards to filing this type of claim, about where to receive medical treatment. A lot of times there is a nurse or company nurse that's there on site. Other times there is a certain doctor that your employer will want you to go to if you're injured on the job. In the event that there is a delay in finding out who you're supposed to see or which medical provider you're supposed to see about your injury, it's important that you go on your own. Go to the emergency room if needed or your family doctor, because the only way to document the injury is going to be to show proof through a medical record that that injured worker received medical treatment. Now, I'd like to make a couple of points about that first visit to the medical provider. When you go in and see the medical provider, they're going to request information from you. They take what's called a history, they take complaints of pain, they find all of this information out from the patient. It's important to explain to the doctor or nurse how the injury occurred. A lot of times I hear from people that they assume the doctor knew about how the injury happened. Therefore, they didn't explain how they were hurt. It's important that you're as clear as you can about the fact that you injured yourself on the job. I've seen so many claims wrongfully denied simply because that worker did not explain to the doctor that they were hurt on the job. And whenever that document is reviewed later, the adjuster who is looking at whether to accept the claim or deny it, if they see that there is no mention of the injury in the initial medical record, they will use that to deny a claim. And this is true even if there has been a written notice of the injury. So it's important to explain to the doctor in detail how the injury occurred. A lot of times there'll be an intake sheet or information that a patient is required to fill out. Include the type of injury that happened in that information. Not only should you report or explain how the injury happened, but you need to be as specific as you can about complaints of pain. Here, don't be vague. If you injured your back, if that's the injury, you need to explain what type of pain it is, where it is in your back. If you injured multiple body parts, you need to explain each and every body part that was injured. And this is going to be important, remember, because someone else is going to be looking at this document, determining what type of treatment you need, and even whether to accept the claim or not. So take this time when you first see the doctor to be as detailed as you can, not only about how the injury happened, but about your complaints of pain. Give the doctor as much information as you can. Now, this is true during the course of the treatment. Not only should you do this after the initial injury, but each and every time you go to the doctor or the medical provider, sometimes it's a nurse or a licensed practitioner, explain all of your symptoms, your injuries. Remember, this is different than just receiving treatment for a normal injury. This is a workers' compensation claim, and it's more or less an insurance claim. And so it's going to be important, in order for you to protect all of your benefits, to be on record with the doctor each and every time you receive medical treatment. Let's talk now about the duties and responsibilities of the employer once there has been an on-the-job injury. The primary responsibility is to provide notice of the injury to the Workers' Compensation Insurance Carrier and to the North Carolina Industrial Commission. Of course, your employer cannot provide notice until they have actual notice. Most of the time, they'll get that notice from the employee. But once the claim is made, then there'll be an insurance adjuster assigned to the claim. And I want to talk about what the basic duties and responsibilities are of the insurance adjuster. The first is to open a file and to investigate the claim. The adjuster will request certain documents in order to make that investigation. These include any written notices of the injury, medical records, witness statements. Sometimes they will take a recorded statement from the injured worker. This is all part of the investigation, because the first important decision that the adjuster will make is whether to accept or to deny a claim. That's why when we spoke earlier about the importance of documenting in detail the injury and documenting the injury in medical records, it's because it's very likely that an insurance adjuster is going to look at these documents when they make their decision. Now, the second responsibility of the adjuster is, once the claim has been accepted, is to pay benefits. And I want to talk more in detail about those benefits in just a minute. But the adjuster will be the one responsible for issuing the checks on time, will be responsible for authorizing medical treatment. And the adjuster is going to be the one who has to make those decisions through the course of your claim. The final responsibility of the adjuster is to settle the claim and close it. Adjusters are assigned many cases, many claims, sometimes up to 300. They don't want to leave a claim open indefinitely. They're interested in closing the case at the right time. And so I believe also that any injured worker who has a workers' compensation claim, at some point their case has to be resolved. The insurance adjuster may make the decision what the case settles for and ultimately how it is concluded. Let me make another point about the insurance adjuster. These are professionals, trained professionals who understand and have been taught the laws of workers' compensation in North Carolina. They understand what benefits are owed. A lot of them are very nice. But if there's one piece of information that you can take with you from this informational DVD, it's this. The insurance adjuster does not work for you. They do not work for the injured worker. They work for your employer, and they work for the insurance company. Their interest is with the insurance company. And for this reason, they're not under any obligation to explain each and every benefit that you're entitled to. They're not obligated to pay for 1 cent more than they have to. In fact, adjusters are motivated to settle claims for less than what the claim is owed. What are the basic elements of a workers' compensation claim? In other words, what is the injured worker entitled to receive whenever they've been hurt on the job? The first benefit is medical treatment. The employer is responsible to provide medical treatment which is reasonably related to the injury. And this means that it's going to be the adjuster's job to identify the appropriate treating physician for the injuries and to authorize any tests or any orders or any referrals made by the treating physician. With workers' compensation, you do not have the right to treat with your own doctor. You can do so, but it's going to be your responsibility to make those payments. The exceptions to this rule is, first, the injured worker has a right to a second opinion regarding the impairment rating or the work restrictions. Also, there are certain times when it's appropriate that another physician get involved or that care be transferred. The injured worker and the adjuster can always reach an agreement about transferring care to another physician. In the event that there cannot be an agreement, the injured worker can file a motion with the Industrial Commission requesting an order that the carrier or the employer approve the new treating physician. The second element or benefit is wage replacement. An injured worker is entitled to have their wages replaced as long as they're out of work. And this is sometimes called payment of compensation or disability compensation. And in order to receive that benefit, your treating physician must either take you out of work completely or provide work restrictions that your employer is unable to comply with. Now, another point about wages. Once the correct compensation rate has been determined, that amount will not go up. It does not go up with inflation, and it does not go up with the price of gas. This is why it's critical that that compensation rate be calculated correctly. This is because the injured worker will have to count on that payment as long as they're out of work, and that could be weeks, months, if not years. And I can promise you the bills will not stop coming in the mail just because you have a workers' compensation claim. The last benefit of a workers' compensation claim is for a permanent injury, and this really takes two forms. The first is once the injured worker has been released and the doctor determines that they have a loss of use or they have not regained full use of the injured body part, and assign an impairment rating, meaning this is a number that represents the percentage of loss of use of that body part, then the injured worker is entitled to a lump sum amount based on that impairment rating. When I spoke earlier about the right to a second opinion, an injured worker, if they're not happy or satisfied with the impairment rating given by the treating physician, is entitled to have a second opinion regarding the rating. Let me give you an example of the impairment rating and that benefit. With workers' compensation, each body part is assigned a certain number of weeks. And so if, for example, an injured worker